Started here shortly. We've got one board member that's catching a ride in here. We hope his car broke down, but he's very close. If you haven't and you want to, and you see your code enforcement officer here and you want to speak to them about any possible resolution or anything, feel free to do so. But we should be started here within the next 10 minutes at the most, I would think. Maybe 5. Good afternoon. We're going to go ahead and get started. Welcome to the August 24th, 2023 Code Enforcement meeting of Seminole County. I'd like to first start by asking the clerk to conduct a roll call.
Catherine Townsend.
Present.
Dudley Bates.
Here.
Kevin Ross Andino.
Present.
Don Peterson.
Here.
Dennis Warren.
Here.
Craig Davis.
Here.
Yvette Brown.
Thank you. And let's stand for the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. If you're going to be testifying today, remain standing and raise your right hand so you can be sworn in by Madam Clerk, please.
If you're going to be testifying in a case, do you swear affirm the testimony you're about to give us the truth? Thank you.
And before we get going, I'd like to suggest that we revise the agenda with just a minor change or two in order for us to take those that are present here, and then we'll do the remaining cases thereafter. That would mean we would start with case number 23-36 CEB, which is on page 1, followed by on page 3, case number 23-38 CEB. We'll take those two cases first if this motion passes, and then we'll take the rest of them after that. Do I have a motion to that effect?
So moved. Second.
Motion by Mr. Peterson, second by Ms. Townsend. All in favor, say aye.
Aye.
Opposed? That's what we'll do. So we're going to, let me, excuse, I have to read some information here. It's easier for me to read than try to memorize it. Again, good afternoon. Welcome to the August 24th, 2023 hearing of Seminole County Code Enforcement Board. I'd like to advise everyone about the procedures that govern appearances before the Code Enforcement Board. This meeting is open to the public under Florida's Government and Sunshine Law. Therefore, every effort will be made to hear all persons having relevant evidence or arguments to offer. It is required that every person who appears before the Code Enforcement Board needs to be registered with the clerk. If you haven't already done so, please do so now. The cases where the respondents are present will be signed in and heard first. You will be sworn in or affirmed by the clerk. Once all cases where the respondents are present have been heard, the Code Enforcement Board will hear the remaining cases as they appear on the agenda. When your case is called, please be seated at the table reserved for the respondents. The county will present their case, and then the respondents will be allowed to present their case. Additionally, please limit your comments only to the information relating to this case. Each party may question witnesses offered on behalf of the other party. Additionally, staff members may question those appearing before the Code Enforcement Board. The board will then make their decision based upon the evidence and testimony as presented by both parties. All proceedings before the Code Enforcement Board are electronically recorded. Please speak directly into the microphone at the center of the table and state your name clearly before presenting your case. Should you need assistance due to a hearing impairment or a language barrier, please inform the clerk upon registration. All cell phones and other electronic devices are to be turned off or silenced while inside the chambers. Thank you for your cooperation. With that information, we'll get started with case number 23-36 CEB, JCMJ LLC, Christine Crow, registered agent, 1980 Cameron Avenue, Sanford, Florida, 32771.
Mr. Chairman, I'd like to be recognized.
Go ahead, sir.
I have knowledge of this case. I've talked to no one since I was appointed to the board, but I'd like to recuse myself.
Certainly, that should not be a problem. Any issues with that from anyone? So we have a quorum here? Okay, thank you for that. I'm sorry, does county have any issues with that?
No, that's fine.
Okay. That being said, we'll go ahead and get Oh, sir, I'm sorry, whoever's here to testify. And when you get seated, if you could tell us your name and your relation to the case.
My name's James Crow. I'm the owner of the property, 1980 Cameron Avenue.
Okay, thank you. And you go ahead and have a seat, and you've been sworn in, sir? You were sworn in, correct, sir, Mr. Crow? Thank you. Okay, go ahead and begin, please.
Officer Henson, Seminole County Sheriff's Office Code Enforcement. For the record, I'm submitting a copy of this presentation to the clerk as Exhibit 1. This is case 2336 CEB, JCMJ LLC with the registered agent of Christine Crow. The violation is located at 1980 Cameron Avenue, Seminole County, Florida, as determined through the property appraiser's office. The violation charged as Seminole County Code 30, Part 47, Section 30.882, concrete crushing is not permitted, a permitted use in an M1 zoning district without a special exception. I first observed this violation on March 16th, 2023. A notice of violation was issued May 16th and one June 20th, 2023, with the compliance date of June 5th, 2023, and July 5th of 2023. The follow-up inspection was on June 15th, 2023, June 19th, 2023, July 6th, 2023, August 9th, 2023, August 10th, 2023, and August 23rd, 2023. The results of the follow-up inspections for unpermitted use no longer remains on the subject's property. This photo was taken, This photo was taken on May 16, 2023 by myself, which depicts the concrete crushing as not a permitted use on an A1 zoning district without a special exception. These photos were taken on June 15, 2023 by myself, showing the business of not crushing concrete. On June 16th, 2023, they were not crushing concrete. The next photo was taken on July 6th, 2023. They were crushing concrete, I'm sorry. On June 16th, they were crushing concrete, 2023. The next photo on July 6th, 2023 by Specialist Henson, showing the concrete crushing continued. The next photo was taken July 18th, 2023. And the crushing was still continuing on. This next photo was taken on August the 10th, 2023, when I posted the notice of hearing, and at this time there was no crushing and there was no longer remained the crushing on the property subject property. Sorry. And this photo here was taken on 2023 yesterday, and there was still no concrete crushing. Based on the testimony and evidence presented in case number 2336 CEB, it was determined that the respondent at JCMJ LLC is the owner of the property located at 1890 Cameron, located in Seminole County, as determined by the property appraisers in possession and control, and was in violation of the Seminole County Development Code, Chapter 30, Part 47, Section 30.882, uses permitted. And it's further recommended that the Code Board issue an order for the respondent to refrain from repeating the violation on or after midnight, September 1st, 2023, that a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you. Any questions for Officer Henson? Seeing none, Mr. Crow, this is your opportunity to respond to this. It appears that you are in compliance, and the recommendation by staff is to not violate again from September 1st forward, or there'd be a fine of $100 per day. So that's what we're here to discuss today. You got the floor,
I'm
sir.
good with that. I'm in compliance.
What's that?
I said I'm in compliance. I'm done
Oh, okay,
questioning.
okay. Thank you. Any questions for Mr. Crow or Officer Henson? Seeing none, again, the recommendation is to come to compliance, or not to re-violate past September 1st, 2023, or $100 per day fine. I have a motion.
So moved.
Motion by Ms. Townsend, second by Mr. Bates, to accept staff's recommendation as recommended. All in favor, say aye. Aye. Opposed? Sir, that's what we've done. You're in compliance, and just try not to get in that position again, and you'll be in good shape.
All right, thank you.
Thank you for coming in. Brings us to the second case we'll be hearing. It's on page 3. We have this, let me see, no? No. This one?
Nope.
Oh, I got you. Okay, I'm sorry. Okay, case number 23-38 CEB, Luis Silva Jr. and Danielle Souza, 5160 Plato Co., Sanford, Florida, 32773. If you're here for that case as a respondent, please come up to the table. And once you get seated, if you could each state your name, ma'am, beginning with you, please.
I'm Danielle Souza.
Luis Silva.
Thank you. And I saw you were sworn in, so Officer Henson, you can begin.
Officer Henson, Seminole County Sheriff's Office Code Enforcement. For the record, I'm submitting a copy of this presentation to the clerk as Exhibit 1. This case is 2338 CEB, Luisa A. Silva Jr. and Danielle M. Souza. The violation located at 5160 Plato Cove, Seminole County, Florida, as determined through the Property Appraiser's Office, Seminole County, Chapter 95, Section 95.4, as defined in 95.3G, an unsecured swimming pool. I first observed the violation on February 2nd, 2023. A notice of violation was issued on May 19th, 2023, and June 13th, 2023, with compliance dates of June 2nd, 2023, and June 28th, 2023. A follow-up inspection on May 2nd, 2023, May 17th, 2023, May 19th, 2023, May 31st, 2023, and then July 3rd, 2023, August 10th, 2023, and then yesterday, August 23rd, 2023. The results of the follow inspection, the violation of an unsecured pool remains on the subject's property. These photos were taken on May 19th, 2023 by Officer Henson showing an unsecured pool. These photos were taken on May 31st, 2023 by myself. These photos were taken on July 3rd, 2023 by myself. These photos were taken on August 10th, 2023 when I did the posting of notice of hearing. And the violation still remained. The suggested recommendation is based on the testimony and evidence presented in case 2338 CEB is determined that the respondents, Luis A. Silva Jr. and Danielle M. Souza, is the owner of property located at 5160 Plato Cove, located in Seminole County, as determined by the property appraiser, in possession of the control of the property and are in violation of Seminole County Code, Chapter 95, Section 95.4, Section 95.3G, an unsecured pool. And further, the further recommended of the Code Enforcement Board is to issue for the respondents to correct the violation on or before midnight of September 8th, 2023. In order to correct the violation, the respondents must secure the swimming pool with a barrier at least 48 inches in height from the ground up with self-closing, self-latching mechanisms. If the respondents do not comply by the order, a fine of $250 will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact Officer Henson to have a follow-up inspection to verify compliance. This concludes my presentation.
Thank you. Any questions for Officer Henson? Mr. Bates?
Officer, I couldn't really tell from those pictures, is the pool completely open, or is it a matter of an open gate, or one wall is down, or what is the nature of the open pool?
There is no fence all the way around the property, so for temporary protection, they put an infant fence around until they could, at some point, get a fence put up, a permanent fence.
Okay.
Mr.
I
Russell?
assume it's an in-ground pool?
Yes.
Okay, that's why I'm having trouble seeing it, okay.
How high is an infant fence?
4 feet tall.
4 feet tall.
Any other questions? Officer Hanson, this is just the unsecured pool that we're dealing with. It's the first few lines, and the fence looks like it has to deal with something else. Okay.
Yeah, I think I had something in there with rubbish that has to be taken out. I think it's part of the 95, but I didn't.
Okay, okay. Any other questions? Okay, but folks, it's, the floor is yours to respond to this. State your name, please.
Yes, my name is Luis Silva, and I'm the owner of the property in question. I do have pictures of the 4 feet tall infant fence around the pool, and this was temporary for us to indeed get a fence around the property line. And that's been our goal. That's what we've been trying to save for that. And we haven't done it as of right now yet, of course, because of the finances. We've gotten some estimates, and the finances are not there yet for us. The reason being, it's because we're both self-employed, and a couple months ago, I did not have work for a month and a half, a full month and a half. So for us, that's a little bit hard, but we're basically just getting back into businesses and closing some contracts. I work in the home remodeling business. So for me, it's catching up, it's picking up. So, and our plan indeed is to fence the entire lot and comply with the code, of course. And it's just a matter of time. We do indeed need more time.
Yeah, my name is Danielle Souza, owner of the property. And as I spoke with Officer Hanser, last night we did remove the old fence, the white fence that you guys see on that picture. I have here on my phone. Also, I have 3 estimates here for the new fence that we want to put around the property. One is $25,000 quote, $18,000, and the other is close to $18,000 as well. I have 2 other quotes scheduled, one for Saturday, one for next Wednesday. And I've been telling her, like my husband said, we've been to a financial situation now. Our credit scores are really low. I brought here as well proof to show that. We have we have many credit cards. I have a letter here as well stating that we weren't approved for a loan of $19,000 so we can get the fence around the property.
That we were not.
That we were not approved because of bad credit, because of credit cards. They're all maxed out. And like my husband said, we're trying to get back up, but we do want to fence the property to resolve this issue, and we're just asking for more time because we need to get the means to get this resolved as soon as possible.
Do you have an idea of how much time you're asking the board for?
We would probably be minimum about 6 months, if that's okay.
If that's possible.
If that's possible for us to
Let
get
the
back.
board discuss it. I will say this, that the unsecured pool violations are a serious matter as far as the county's concerned for obvious reasons. So I'm not sure.
Can
Mr. Ross?
I ask Officer Henson a quick question?
Yes.
Is there anything they can do on a temporary, when you're considering the additional time, obviously it's not safe, is there something they can do to make it a little less hazardous, to give them, not saying 6 months, even a month more, is there something they can do to the pool so it's a little safer than what it is now, or is this just really nothing that they can do without a fence?
Other than drain it maybe and cover it, and they do have the temporary infant fencing up. Okay. Officer Hill said they couldn't make the baby gate a self-closing, self-latching gate until they can get that taken care of. So it has to automatically have a, like, spring on it to make it close. Okay, that would suffice to make the pool secure.
Did you all hear that?
Yes.
Yes.
So having a baby gate on that fence would bring them into compliance? Why don't you get sworn in? Identify yourself for the record.
Officer Hill, Seminole County Sheriff's Office Code Enforcement. So they do make latches where they can make the baby gate self-closing, self-latching. Also, you could get a building permit where you make that baby gate, it has to be secured into one point, either whether into the house or into the pool deck, and that would make the pool secured too. So the reasoning behind that with the building department is so nobody can walk away with your baby fence. So it has to be permanently secured somewhere, whether it's to the residence or it's into the ground of the pool.
And that brings
pool
them
deck.
into compliance?
Yes, ma'am.
It's a less expensive option.
That's why I asked. Anybody else?
Now you aesthetically understand.
Did you all hear what she said, and did you understand?
I don't know, is that
So
possible?
basically what she's saying is, I can, if we, this is basically drilled to the concrete and it's just inserted. So to comply, then I would have to basically make it permanent.
Well, I'll let
And-
her tell you on that, but it sounds like a gate that meets the conditions will suffice, correct? As opposed to an entire fence line, is what it sounds like, will get you at least into compliance. I'm not saying don't get the fence, but permanently mounted. And do they have to get a permit for that?
I would double check with the building department
Okay.
just to verify, but it has to be, and so somebody can't walk away with their baby gate, so it has to be permanently into the ground or attached to the residence.
And how long is that temporary fix good for?
That would be considered a temporary fix.
That would bring them into compliance. That makes that baby gate compliant pursuant to the ordinance.
I think they use the word temporary just as we're trying to get the fence in the meantime.
So that gate would make that a temporary fence around their pool? I mean, a permanent fence around their pool?
So because we just had a meeting with the building department not long ago because we had some differences in our code and their code. So for a Seminole County Building Department, for a pool to be secured, their black baby gate, somewhere it has to be permanently secured to the house or into the ground so nobody can walk away with it, and they would consider that as permanent as securing the pool.
So the word temporary is just being used for their future plans, but it's not really temporary if they make it permanent.
Any other, do you all, you follow this, correct?
Yeah, just to confirm if I am following. So then, in order to, the least expensive solution to the problem that we're getting to now, it's this fence, or infant fence around the pool. So if I make it permanent to the concrete
With a self-latching door.
with a self-latching door, then that basically bring me to compliance.
Don't have to have the self-closing, self-latching mechanism if it's secured permanently to the house or into your pool deck.
Okay. Okay.
Okay.
So then, yes. So then it would make us compliant, yes. If we,
But that's the school enclosure.
So now the board needs to decide how much time they'd like to give the respondent.
So I have an idea for motion if anybody, unless somebody else has questions. Okay. So here's my recommended motion. I move that we modify the staff's recommendation like this. give them until the 8th to come up with the solution we've just discussed, which means you need to talk to them and make sure you're complying with it. If it's in compliance, then you won't need to do anything. If you don't, we're going to be back here again. So I would say give them to the 8th to come into compliance with the suggestion that we had at this hearing. If they don't do that, as opposed to fining them necessarily, I don't know if we just need to revisit it again, because that should be the permanent solution other than the big fence.
So it sounds like you're asking for this matter to be continued.
Correct. So my motion is to continue it. I think that they should talk to I think there is a gap between their understanding, and that they should have until the 8th to figure out if they can come up with the solution that's been recommended today. And if they can't, I think then it would make sense to say, okay, that's not doable, and let's fine them if they can't fix it. So my motion is, let's adjourn the decision on fines and everything until the next code enforcement hearing. Give them to the 8th or before that hearing to figure out if they can solve the situation as we discussed today.
Continue to our 28th,
Correct.
September 28th hearing?
Correct. So we would continue it until then before we do any fines or anything like that, to give them the opportunity to explore this solution that came up during the hearing to see if it's actually doable.
I'll be in training the next code board meeting, so I won't be here.
Anybody opposed to putting it on the October one?
Moving it to October or September?
If necessary, if necessary, right?
necessary,
Because if
yeah.
it's in compliance, you don't have to bring it back.
Correct.
If necessary.
So it'd only be, so I'm just saying, continue it. If it's necessary to come back, they'll just notice it a new hearing. But to give them, but do say we want them to get to the solution by the 8th. I don't want it to continue. If they go back on the 8th and there's no solution and they can't fix this, we need to come back here with a more permanent solution, or fine, or whatever we're going to do. If that makes any sense to anybody at all.
I'll second that.
Continue, let me make sure I'm clear on the motion. I guess we're either going to continue it to the 28th, and September 20th, but the 8th, but you want them to come into compliance by the 8th.
Right. I want them not to wait till the last minute and then we're in here and we're being asked for additional time, because I won't be inclined to vote for additional time. If they can't fix it with the solution discussed today before that hearing, then they can't fix it.
Okay, so you want them to come in compliance by the 8th, or the fine will start then, and to continue, and then to rehear it?
So I'm not voting for, I'm not suggesting any fine. I'm just, so I'll say it slower. Given what we heard today, and I think there's a solution that they've never contemplated, there's probably a way with what they have, they can come into compliance pretty quickly and affordably, to give them the opportunity to do that, because, and then revisit it, because it doesn't sound like they're going to be able to do the other one for many, many months. And so we might as well just not give them any. If that's the only solution, then they're just going to be not in compliance. So I'm asking or moving that we give them the opportunity to see if this fix can actually resolve the situation, so we won't have to do this again.
So it's just resetting this for the 28th of
Right.
September?
And if they can't fix it by then they just can't fix it.
Okay, I understand. Everybody clear on that? To table this to the September 28th meeting and rehear it if needed? Motion by Mr. Ross, second by Ms. Townsend. All in favor, say aye. Aye. Opposed? So that's what we've done. The expectation and hopes are you can get it done by the 8th. If you're not done by our next hearing, we're going to have this in front and discuss fines and all that stuff. So hopefully it sounds like maybe a good solution for you all.
Thank you.
Thank you for your diligence on work, and I know you've got a lot of time into this. Much appreciated.
Thank you.
Thank you. Okay, again, bring us to case number 23-39 CEB, HPA Borrower 2016-2 LLC on page 4.
We'll get back to it. We'll get back to it. We'll get back to that one. Yep.
Okay, Officer Hill, whenever you're ready.
Officer Hill, Seminole County Sheriff's Office, Code Enforcement, East Region. For the record, I'm submitting a copy of my PowerPoint to the clerk as Exhibit 1. This is case 2339 CEB, respondent HPA Barrow 2006-2 LLC. Property is located at 759 Franklin Street in Altamont Springs. Violations charged in Seminole County Code, Chapter 95, Section 95.4 is defined in 95.3B, uncultivated vegetation. My initial inspection was on March 7th, 2023, with notice to respondents on March 8th and April 5th, 2023, with compliance dates of March 29th and April 19th, 2023, with multiple follow-up inspections, including yesterday. The results of my inspection is the violation of the uncultivated vegetation no longer remains on the subject property. These photos were taken on my initial inspection on March 7th, 2023. These photos were taken on March 30th, 2023. These photos were taken on March 30th as well. These photos were taken on April 19th. These photos were taken on June 1st. Same date. These photos were taken on June 27th, 2023. This was a posting done by Officer Cameron Adair for me on August 9th, 2023. These photos were taken yesterday. Based on the testimony and evidence presented in case 2339 CEB, it is determined that the respondent, HPA Barrow 2016-2 LLC, is the owner of record located at 759 Franklin Street in Seminole County, in possession or control of the property, and was in violation of Seminole County Code Chapter 95, Section 95.4 is defined in 95.3B. It is further recommended the Code Enforcement Board issue an order for the respondents to remain from repeating the violation on or before midnight of September 7, 2023. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you, and I just want to read into the record, although it was in the presentation, the address for this case is 759 Franklin Street, Altamont Springs, 32701. Any questions for Officer Hill?
Have there been obviously no one showed up, any communication with the property owner?
So this is a rental property. It is owned out of Chicago. So the first time, my initial inspection, it did not appear like anybody lived there. So I sent out my first notice of violation. When I went out for my follow-up inspection, this time I actually saw some dogs in the window. I knocked on the door, left my door hanger, hopefully getting maybe a phone call from the tenant. At that point, still no compliance, so I started doing some research looking for a contact phone number in Chicago to talk to a live person. I ended up talking with a Miss Ricci. She is with Pathlight Violations. This is kind of the company where the tenant has an issue. They go through them because there were other code violations that they did comply with. And so she's a little delayed with her emails. She'll call me and say, oh, the grass was cut, but I don't get that email for like 3 weeks because I don't actively work this area since I'm Oviedo, Geneva, and Toyota. So back and forth we've been through, and I will send her photos. It got cut, but it's still at the 8-inch mark, and I would recommend you get this on a schedule because being here in Florida, the grass is growing like crazy. Should be cut like every week, every 2 weeks. So she's finally got it on a schedule. She's supposed to send me a contract, but I told her I was still getting an order on it because the owners are not local, and they also could not get a hold of the tenants either.
So this is in compliance, and she's looking for an order that it was in violation, so if there's a future one, the fines kick in immediately. That's where we're at. And any other questions for Officer Hill? Her recommendation is to, well, it's in compliance, but it says by September 7th or $50. Any violations after September 7th would be a $50 per day fine from this point forward is the recommendation.
Hey, make a motion
Yes, sir.
that we accept the officer's recommendation and continue forward, hoping they clean it, keep it cut.
Motion by Mr. Peterson to accept staff's recommendation.
Second.
Second by Mr. Bates. All in favor, say aye.
Aye.
Opposed? Motion carries. Brings us to case number 23-37 CEB, Tiffany Walgast, Paula Walgast, Shia, 200 Lakeview Drive, Sanford, 32773. and bring to your attention, there was a document that was handed out. If you haven't read it, if you take a quick look at it, it's a request by the attorney for the respondent asking to continue this case until another date.
So it appears that the attorney is a co-respondent. If you look at the name
Oh, yeah.
on the request, she's also the first named respondent. And so when you don't see a lot of these, so when you see it, you take the time to read through it, and then the chairman needs to find out what the county's position is with regards to the respondent's request. And then based on that information, you make your determination as to whether you're going to continue the case at the respondent's request or hear the case.
Officer Henson, any comments as far as the county's position on whether we should continue this or not?
I would like this case to be presented today. I've been working with her since November 2022, and we've worked on and off, back and forth, and she still's not come completely into compliance.
Okay. So with that, we are...
Can I ask a question?
Yes.
Are there any health, safety, welfare concerns?
No, ma'am. And I'll be in training on the next code board.
Okay.
When was the notice of hearing posted?
Pardon me?
When was the notice for this posted?
On the 10th of August.
So I've reviewed the file, and it looks as though the certified letter was sent to the respondent timely. The county has not received the green card back yet, so the county's policy is when you don't get that green card, you go ahead and you post it to make sure there's no violation of due process. So there doesn't appear to be any violation of due process with regards to this matter. What I'm hearing is there are no health, safety, welfare concerns. I also understand that the clerk reached out to the respondent in response to this because this was originally sent to the clerk, and it probably should have been sent straight to the code officer, who's the party bringing the action. And so the clerk advised the respondent that there was no guarantee that the continuance would be granted, and that she was highly it was recommended to her that someone appear on her behalf, just in case the board decided not to pursue or to grant the continuance. If you look at clause number 6, it says a public records request was submitted to Seminole County, and it's my understanding that that request was made last Thursday? Last Thursday, is that correct? And did the code enforcement office also receive that request last Thursday?
Yes.
Okay, and have you had time to fulfill that request?
The Sheriff's Office Records Department did do that request, and they sent it to the county. I'm not sure if they got their files all together yet, though.
So it takes a little bit of time to put all the paperwork together. So arguably today would be Friday, Monday, Tuesday, Wednesday, Thursday, the 5th business day. So it may be that those documents have not yet been sent out or received by the respondent.
I have a question. The last 5 days notwithstanding, did I understand that they have known since last November that they were not in compliance?
Right, yes.
That's what the testimony was.
And can you put back there, because I didn't look at it, the different dates of notification, or just give us a brief rundown?
Yeah, she can't do that yet. She can tell you, though.
Okay.
You haven't decided if you're going to see the case.
Okay.
You can tell them.
I'm ready to make a motion if you want. I don't need to see it. I move that we deny the continuance. Unless somebody feels they need to deliberate it, I'm ready to move to deny the continuance. I think she's had more than enough time, and
Exactly.
I'm a lawyer. We know how to stall things. This sounds like a stall tactic, and they could show up. And I just don't think there's a good reason to file something the last minute when you know since November. So I move to deny the continuance and proceed.
I'll second that.
Okay, we have a motion on the floor to deny the continuance, second by Mr. Ross, second by Mr. Bates. Any further discussion? All in favor, say aye.
Aye.
Opposed? Okay, so we're going to hear the case now, which we just heard. Okay. Can I see, again, can you flip to the different notifications?
I first inspected the property on the 4th, 2022, and then she was cited for her first violation November 30th, 2022, a second one December 22nd, 2022, with compliance dates of December 16th, 2022, and then January 5th, 2023. I continued to work with her all the way until the first part of July.
Thank you.
All right, start at the beginning.
We
Pardon
have,
me?
She needs to present evidence.
go ahead, I'm sorry.
Start at the beginning of your case.
Seminole County Sheriff's Office Code Enforcement, Shannon Hinson, North Region, case number 2337 CEB, Tiffany A. Walgast and Paula G. Walgast Shea. The violation is located at 200 Lakeview, Seminole County, Florida, as determined through the Property Appraiser's Office, Seminole County, Chapter 95, Section 95.4, as defined in 95.3A, rubbish. I first observed the violation November 4th, 2023. A notice of violation was issued on November 30th, 2022, and December 22nd, 2022, with a compliance date of December 16th, 2022, and January 5th, 2023. Follow-up inspections were done in November 17th, 2022, November 21st, 2022, December 20th, 2022, January 4th, 2023, January 20th, 2023, February 1st, 2023, May 2nd, 2023, July 3rd, 2023, July 28th, 2023, August 10th, 2023, and August 23rd, 2023. Results of the follow-up inspection, the violation of rubbish remains on the subject's property. These photos were taken November 4th, 2023 by myself showing the rubbish. These photos were taken December 20th, 2022 by myself. This photo was taken January 4th, 2023. And these photos were taken the same day. This photo was taken February 1st, 2023. These photos were taken July 3rd, 2023. These photos were taken and also those are on the 3rd of July. These ones were taken then the 28th of 2023 by myself. And these photos were taken on August 10th, the day I posted notice of hearing, and the rubbish remained. These ones were taken yesterday, 2023, where the violation still remains. Based on the testimony and evidence presented in this case, 2337 CEB is determined that the respondent Tiffany A. Walgast and Paula G. Walgast Shea is the owner of the record of property located at 200 Lakeview, located Seminole County, as determined by the property appraiser's record, in possession or control of the property, and are still in violation of Seminole County Code 94.4, Section 95.3A, rubbish. It's further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of September 8, 2023. In order to correct the violation, the respondent must remove all of the rubbish from the subject's property. If the respondent does not comply with the order, a fine of $100 will be imposed each day the violation continues or is repeated after compliance. The respondent must contact me for me to inspect the property to verify its compliance. This concludes my presentation.
Thank you. Any questions for Officer Henson? Mr. Bates?
In this 9-10 months since you started all this, have they offered any excuse, reason, whatever, for this continuing mess?
There's been a lot of different issues on the property, and she has also tried to comply a few times. She's got a dumpster. She would contact me, and some rubbish would be removed, and then other rubbish would be returned. So it wasn't always consistently the same rubbish.
Do they live?
Are other people using it as a dump or something, or
No, it's all.
they're doing their own? Okay.
Do both or either of them live in this house?
Yes, Tiffany Walgast does. The other one is, owner is her mother.
I'd move the officer's recommendation.
Second.
Motion by Mr. Bates, second by Mr. Peterson to accept staff's recommendation as presented. Any discussion? All in favor, say aye.
Aye.
Opposed? Motion carries. Okay. I think that may be it. So let's see here. Cases that came into compliance prior to the hearing, you can look at those on your own. Other business, anybody have any other business they feel needs to be discussed? Approval of the minutes we're going to do at the next meeting. Confirmation date of the next meeting, September 28th, 2023. If anybody has any issues with that, please let the clerk know as soon as you know that. And any other business needs to be discussed before we ask for a motion to adjourn?
At that
So
next
moved.
meeting, oh, sorry,
Oh,
you cut me off. At the next meeting, you'll also be electing a vice chair.
Yvette, I have a question. If I have to have an excused absence for things, do we have to talk about it like this, or do we talk about that off?
Talk about it privately.
Okay.
Motion by Mr. Bates to adjourn, I believe it was.
Second.
Second by Mr. Peterson. All in favor, say aye. Aye. Opposed? Thank you. We'll see you all next time.